In North Carolina, mediation isn't just an option. For most divorcing couples, part of it is required. Contested custody and visitation issues have to go to mediation before a judge will hear them, and courts routinely order settlement conferences in property cases too. Here's how it actually works, start to finish. A mediator is a neutral third party. Often a family law attorney certified as a mediator, sometimes a retired judge, sometimes a trained professional from another field. Their only job is to help you and your spouse reach agreement. 3 things a mediator does not do. A mediator doesn't decide anything. Unlike a judge or an arbitrator, a mediator has no power to impose an outcome. Every term of a mediated settlement is one you said yes to. A mediator doesn't give legal advice. Even a mediator who is a lawyer is not your lawyer. And a mediator doesn't take sides. Their loyalty is to the process. Mediation can resolve essentially every issue in a divorce. Custody and visitation schedules, child support, property and debt division, alimony, and the practical details no statute covers. Who keeps the dog? How you'll handle school pickup. Often, and in 2 different ways, custody and visitation are required by statute. When a custody or visitation issue is contested in court, the case has to be set for mediation through the court's custody mediation program before it can be tried, unless the court waives it for good cause. Good cause includes allegations of domestic violence, abuse or neglect, substance abuse, undue hardship, or a party living more than 50 miles from the court. For most families, those sessions come at no charge, and only custody and visitation are on the table there, not money. Property and financial issues are different. In equitable distribution and other family financial cases, courts may order you to a mediated settlement conference before trial, and in most places that is standard practice. Those mediations use private certified mediators, with the fee typically split between the parties. So if you're bracing for a courtroom showdown, understand that the system is built to route you through a settlement conversation first. Because it works. Most cases that go to mediation settle in whole or in part. Most mediations follow the same arc. Introductions and ground rules. The mediator explains the process, confidentiality, and their neutral role. In many family mediations, you and your spouse then move to separate rooms and the mediator shuttles between you. You may never negotiate face-to-face if that's better for your case. Information gathering. The mediator gets each side's view of the issues and the facts. In financial mediations, this rests on full disclosure. Hiding assets doesn't just poison the process, it can unravel any agreement you reach. Negotiation. Offers and counteroffers move through the mediator, who tests positions, floats options, and helps both sides see what a judge realistically might do. This is where the creative solutions happen. Trade-offs and custom schedules no court order would ever contain. And writing it down. If you reach agreement, the terms go in writing before anyone leaves. Sessions run from a couple of hours to a full day. Patience is part of the strategy. Deals frequently come together at 4:30 in the afternoon after a slow morning. Yes, and this is one of mediation's biggest advantages. Court proceedings are public record. Mediation is private. In the court's custody mediation program, what's said in the sessions is privileged and can't be used later in court. In ordered financial mediation, statements made in the conference are likewise generally inadmissible in later proceedings. That protection is exactly what lets people speak honestly. Float a compromise, admit a weakness, apologize without handing the other side ammunition for trial. Confidentiality does have limits. A signed settlement is enforceable, and threats or abuse disclosures are not shielded. Ask your attorney how the rules apply to your mediation. Why mediation usually beats litigating. Control. You write the terms instead of a judge who has known your family for a few hours. Settlements you author are ones you're likelier to actually live by. Cost, because even a paid private mediator costs a fraction of trial preparation in a contested hearing. Speed, because mediation happens on your calendar, not the court's crowded one. Privacy, because your finances and your family's struggles stay out of the public file. And your kids. A negotiated outcome starts your co-parenting relationship with an agreement instead of a verdict, and your children feel that difference for years. Now, the honest downsides. It can fail, and if it does, you've spent time and money on the way to court, though even failed mediations usually narrow the issues. It requires 2 willing people. A spouse who won't disclose finances, won't budge, or uses the process to stall can waste it. And mediation isn't appropriate where domestic violence makes fair negotiation impossible, which is exactly why the statute allows a waiver. And a mediator can't protect your legal rights. Only your own lawyer does that. Preparation is where mediations are won. Know your goals and rank them. Decide before you walk in what you must have, what you'd like, and what you're willing to trade. You will not get everything, so know what matters most. Bring the numbers. Financial statements, account balances, debts, budgets, pay stubs, tax returns. Custody and support decisions write on real figures, not estimates. Sketch a parenting schedule in advance. Come in with a realistic proposal for the week-to-week schedule, holidays and summers, framed around your child's best interests, because that is the standard a judge would apply anyway. Manage the temperature. You don't have to forgive anyone. You do have to negotiate productively for a few hours. Rehearse how you'll respond when old wounds come up, because they will, and be ready to compromise strategically. Concessions on your nice-to-haves, buy movement on your must-haves. Nothing is lost but time. If mediation ends at an impasse, you have 3 options. Try again later, positions soften, and many cases settle at a second session, or informally in the weeks after a so-called failed one. Arbitrate. A private arbitrator can decide the remaining issues under North Carolina's Family Law Arbitration Act. Faster and more private than court, but binding. Or go to court, where the unresolved issues get tried to a judge. Everything you did resolve in mediation stays resolved, which shrinks the fight. A partial settlement is a win, not a failure. Settling property and support while trying only custody saves enormous time and money. Yes, and this isn't self-interest talking. The mediator can't advise you. They can't tell you the deal on the table is worse than what a judge would give you, and they can't spot the rights you're waiving. Some of those rights, like your equitable distribution and alimony claims, disappear permanently once your divorce judgment is entered. The most cost-effective model for most families is simple: mediate the deal and have your own attorney advise you along the way and review every word before you sign. Most of the families we serve never see the inside of a courtroom, and that is by design. At McCrary Pack, we prepare every case as if it will be tried and work every case to be settled, because the best outcomes are usually the ones you write yourselves. Family law for Iredell, Catawba, Alexander, Caldwell, and Burke counties, where clients are neighbors, not numbers. If you're heading toward mediation by choice or by court order, the full guide is linked below. Reach out and we'll make sure you walk in prepared and walk out protected.